All right, so we are ready to get started. Again, welcome to How to Prevent Customer Disputes. Your presenter today is attorney Louis J. Licata, managing partner of Gertzberg Licata. So Lou, why don't you kick things off?
Thanks, Cassie. Welcome, everyone. I'm thrilled to have you here. Today's going to be fun. These are the kinds of things that put people to sleep when they try to figure out what to do with terms and conditions, but I'm going to try to make it as exciting as possible. Our usual disclaimer, we're trained professionals. Don't try these tricks at home. You might get hurt. And about me, you all know me, I think, or most of you know me. So that's just a nice picture with some things I've done. And basically, where are we today? So, in our Cover My Six, we identify the 6 categories of plaintiffs. The 6 categories are 6 groups of people that can file suit against you. And one of those 6 categories is customers. And as your customer base or your company grows, the potential for lawsuits becomes greater. It's the largest number of potential plaintiffs of all the 6 categories. This is where you can have the most problem. And it only takes really one dispute to cost you a substantial amount of money. And I can give you lots of stories about very good clients with very good intentions who had the wrong terms and conditions, and as a result ended up in litigation, and the litigation cost them several hundreds of thousands of dollars. And then the outcome cost them several hundreds of thousands of dollars. And it really set their business back substantially. And so this is an opportunity for you to learn how to avoid those situations. The other part that you'll appreciate, even though we talk about customers today, a lot of what we talk about today will also apply in terms of protecting yourself against vendors. The same kinds of terms and conditions are in consideration because they're both contracts. With customers, you have a contract. With vendors, you have a contract. And so the key is to understand that every transaction with a customer or a vendor, regardless of whether it's in writing or not, and I have to emphasize that because a lot of times people come to me and say, well, we have nothing in writing. Every single transaction, every single one is a contract. The terms of those contracts, if not controlled by you in a writing, will be controlled by other circumstances or possibly by the law. And the goal here is for you to take control of the contract terms, because the whole idea of a contract is to identify the risk that the transaction has associated with it, and then to deal with that risk in a way that you understand and are prepared to either absorb or transfer. So let's start moving through some of these topics. Here's the basic agenda for today. We'll cover contracts types, optional contract terms, rejection of terms, some things like financial security, because I always get a lot of questions about how do I protect myself, and also these terms can be incorporated into the contract because collection of money owed for goods or services is a risk, insurance considerations. And then I'll briefly touch on the latest, greatest thing of artificial intelligence and ChatGPT and all of our fun efforts to try to substitute lawyers by AI. So let's go to the next discussion point so I talked about how every transaction is a contract. And basically, the 3 elements of any contract are there's an offer, there's acceptance, and there's some consideration. There's something that is exchanged between the parties. That is a contract. The contract can be a consumer contract. You go in, you buy clothes, you buy food. They're offering you food. There's a price, you accept it. The payment is made. That's the consideration. Same with clothes. Or it can be a commercial contract where you simply want to buy paper or you want to sell your services. And it's the same thing. There's an offer, acceptance, and consideration. The essential terms of every contract really include, and there's several, but these are the key ones that we want to focus on, is the price, the time that is of performance, the place of performance, the payment mechanism. Those essential terms, a lot of times, are all dictated by the nature of the transaction. You come into my store, you buy something, there's a price, The time is immediate, the place is there, and the payment is made. A lot of other times, though, there is an order. And the order then has to be for what price, when will it be delivered, where will it be delivered, how much are you paying, when are you paying that, what happens if you don't pay, and other considerations of that nature. In a sales contract, and by the way, the different types of contracts that you might experience or probably experience is, a lease is a contract. Even though that's a real estate contract, it's still a contract. And it has certain terms and conditions. We will not cover leases today. Vendor agreements is one of those situations I just explained before. It's similar to the customer agreement in that you are actually purchasing goods or services from a third party, and there is a contract. And then the purchaser of goods or the seller of goods or services would trigger the other kind of basic customer contracts that we're going to talk about. So a sales contract, you are selling. It spells out rights, duties, obligations, whether it's a vendor or buyer in a sales deal. Within that contract, if you do not address the following topics, they will be addressed for you. Every contract, and first, we always have to distinguish as we're talking about customers and contracts, whether we're talking about customer sales in the consumer sense or in the commercial sense. The customer sale in a consumer arena is very different in that there are typically state regulations like the Consumer Sales Practices Act and other regulations that have to be followed. And there's less opportunity to impose terms on the customer because the state has taken measures or the government has taken measures to try to protect that consumer. These are important because knowing the difference is relevant to knowing whether you have a good contract or not, or are at risk. So let me give you an example. A roofing company. We have a client, he's a roofer. He does roofing for both commercial and for homes. The roofing he does for homes is a consumer transaction. The roofing he does for the commercial world is a commercial transaction. Both of those, he's not doing really anything different, but the customer is different. And when he came to us, he had one agreement that he was using for both. And the agreement was perfectly fine for commercial sales, but not fine for the consumer sales. So we had to really differentiate and come up with two sets of forms so that he could comply with the state laws on consumer transactions. The issues that typically arise in almost every contract, whether written or not, are what are the warranties? What are the damages? Where is dispute resolution taken care of? What jurisdiction or forum or venue occurs on multi-jurisdictional transactions? Indemnification, insurance, and statute of limitations. Now, I'll get into what each of these mean in a minute. I've got a nice chart that we're going to kind of work through for that purpose. So here we go. Again, always recognizing the difference between a consumer and commercial sale. The terms that you want to address are set forth here, and let's talk about each. So warranties there's several types of warranties. There's a warranty of fit for a particular purpose. There's a warranty of merchantability. So, for example, if I sell you a lawnmower, you expect that to cut grass. If it doesn't cut grass, then there should be some sort of warranty that has been breached because that lawnmower is supposed to be fit for a particular purpose. It's supposed to be a grass cutting lawnmower. Similarly, there's merchantability. There's express warranties. I tell you that this lawnmower is capable of cutting a certain amount of grass over a certain amount of area with a certain limited use of fuel. And then you buy it and you find out that it doesn't do any of those things. Those are express warranties that I've represented to you, and those warranties would end up becoming a basis for a return of the product or for a remedy. that would provide for maybe a replacement of the product. In all transactions, the common law provides those remedies. When you go and buy food, there's no written contract. You buy the food, you expect the food to be suitable for consumption. And if it's not suitable for consumption, it's obviously been not consistent with what would be warranties that it is. Those are implied warranties at law that provide protection against all purchasers. In commercial transactions, it's similar. Warranties exist to protect the purchaser of the product with respect to the purpose of buying the product and the type of item that's been purchased. It also protects the purchaser from the representations that have been made by the seller about how good the product is, how durable it is, the longevity of the product. In commercial transactions especially, you'll notice that a lot of things that are purchased have forms. Those forms more recently have become a link to a website that says, see our terms and conditions. And believe it or not, a link to a website on a sales order form is considered to be a valid binding contract in a consumer sales transaction. So knowing what those terms and conditions are very important. The seller wants to limit those warranties. The seller wants to say, nothing we have said to you to make you buy this is going to be a warranty. There are limited applications or purposes for this product. We warrant very limited use of the product, or we warrant nothing. Now, it's important, and we always point this out, for sellers not to completely eliminate all warranties for a couple of reasons. One, it may not be good business. Someone calls you because they want to buy a product, and that product is supposed to serve a purpose, and you're telling me, I'm going to sell you this product, but I'm not going to guarantee or represent that it might do or might not do the job. Obviously, from a business transaction, you want to make the sale. You want to tell the purchaser, this product is going to do what it's intended to do. But you can limit that. You can say this product is specifically limited for the specifications that you provided us, or the purpose of the job that you need it for. And the seller will always want to do that so that broader warranties aren't imposed on that transaction. On the other hand, a buyer might expand those warranties. So I have a lot of clients who have purchase agreements, and the purchase agreements have in them warranties, and the expansion of the warranty is that the product has been represented to serve the purpose required or needed, and will do so, and will maybe last for a certain duration of time. Is good for the warranty is good for, it's like a guarantee that it'll perform without any kind of problem or breakdown. There's warranties against design, against manufacturing, against assembly. And the buyer's goal is to make sure that the reason they purchased that product is included in the terms and conditions of the contract. I bought this product. I bought this car because I was told that it would do all of these things. And I want to make sure that if I buy it and it doesn't do all of those things, I have an opportunity to come back and get the remedy or the replacement or whatever it is that will make me whole or make me happy. Let's skip down to damages, because damages tend to tie into the warranties. So if you and I have a transaction, again, in the consumer transaction, it's pretty much impossible to limit damages in the sense that, not always, but in the sense that if I get sick from food, I can't agree that I'll only be responsible to reimburse the person for the price of the food. I can't limit that damage under the law. But we can control in a commercial sense those damages. We can say, if the product fails, your damages are the cost of the product or replacement of the product, or we will repair the product for you. So what ends up typically happening is the damages are tied into the warranties. If there's no provision in the contract for damages, then the law will impose compensatory damages, which means all the damages that flow in a domino relationship to the initial failure of the product or the failure of the contract service. Just think of A leads to B, B leads to C, C leads to D. That's the damage trail. Those are compensatory damages. And there are circumstances where punitive damages could be available in certain situations, certain situations, unless those damages are addressed as being unavailable in a contract situation. Once again, the goal of the seller is to limit these damages. You cannot have compensatory damages. You cannot have punitive damages. What you can have is the cost of the product, replacement of the product, or some combination or some variation like that. On the other hand, the buyer will want to expand those damages. The buyer will want to say, without being ridiculous, because nobody's going to voluntarily agree to be subject to punitive damages. But the buyer might just say, that as a buyer, all the damages available at common law are available to me. I'm not expanding them beyond the common law. I'm just taking those damages or under the commercial Uniform Commercial Code, which is a code that is adopted by most states and dictates rights and remedies and terms and conditions that are available in the commercial transactions. Those two, warranties and damages, are very important. They're usually tied to each other. The state allows you to address those. It does require that the language in those damages and warranty provisions is sometimes all capped or bold-faced or not capped. So it is important that when you prepare these documents for use, that you have the right language and it complies with the statutory requirements to be effective. Now, when a dispute arises, then you can consider in these terms and conditions, do I want to stay out of court? At common law, there is no, arbitration dispute resolution process. What happens at common law is you go into court and you'll typically get a judge or jury trial. And sometimes the courts have arbitration proceedings or other dispute resolution proceedings available by agreement to try to move cases through the system. This is not something, when you ask in the terms and conditions for alternative dispute resolution, we always recommend at a minimum that there be some form of informal dispute resolution process, which could be face-to-face efforts to resolve a dispute, up to maybe even mediation with a third party, with a mediator. Those are non-binding situations, and those are just good, smart measures to try to resolve a dispute before either party goes into court. The real coin flip for each client is, do we want to stay out of court if we can't resolve it? There are some people who believe, I can't afford to be in court against this big company. So let's take 3M. One of our clients did business with 3M. They always felt, and by the way, 3M has alternative dispute resolution in their terms and conditions. So unless our client rejected them and then 3M probably wouldn't do the contract with them, they're going to be subject to ADR anyway. 3M's view is, we don't really want to be in front of a jury because we're a deep pocket. We don't want juries to feel like this small guy that's doing business with us should have the benefit of the doubt. But those are considerations that you, with your counsel, should evaluate. What is the nature of your business? Is your business appealing to a jury? Is the size of your business appealing to the jury? Is the community nature of where you exist versus who your customer or who your partner in this, does that drive the consideration? So that's a checklist that you go through and you decide, you know what, in these kinds of transactions, we don't want to be in front of a jury. It's too complicated. They won't understand it. We have too much risk. Remember, all these terms are designed to address and shift or minimize risk. And here we're talking about the risk of being in court, the risk of how much it will cost, and the risk of getting a bad result because of who the decision maker could be. Along the lines of the arbitration and the dispute resolution process is, where do you want this to occur? If you don't address where, then there are what we call choice of law, conflict of law, common law approach to, well, where does the dispute get filed? If you and I are in Cuyahoga County and I buy something from you, that's pretty easy. We're both in the same county. Our disputes are going to be resolved in Cuyahoga County. But if you're in Chicago and I'm in Cleveland and I buy things from you, now what happens? Do we go to Chicago? Do we go to Cleveland? Or is it the first person that races to the courthouse? A lot of these should be controlled in the documents. I'm selling goods from Cleveland, Ohio, Cuyahoga County. And I want to make sure that if any lawsuits are brought, they're brought here. And so I put a jurisdiction, i.e. Ohio, and a venue, i.e. Cuyahoga County, or e.g. example, Cuyahoga County, in the agreement. And so all disputes will be resolved there. Now, the buyer obviously is going to want to put their jurisdiction. So then how do you resolve let's say a conflict? We call it battle of the forms. I send over my forms. It says jurisdiction is Ohio, venue is Cuyahoga County, and they send over their forms and they say jurisdiction is Illinois and we're in Chicago. We're in that county. Well, one of the things that we've done on the actual jurisdiction of disputes or the choice of law. So in choice of law, a lot of times we will look and say, well, you know what, Illinois law isn't that different from Ohio law with respect to commercial transactions. So, okay, that's fine. We won't really fight over that. But on the venue and the jurisdiction, we might put it as that the venue and jurisdiction will be where the party who's being sued. So, for example, I buy product from you. I have a problem. I want to sue you. I have to sue you in your jurisdiction. But if I buy product from you and I don't pay you and you want to sue me, or there's another issue in the breach between us, you have to sue in my jurisdiction. I've had a lot of negotiations where the parties have said, you know what, that's acceptable. Because what it does is it makes people think twice before going into court. And that assumes, by the way, that both parties don't want, or one of the parties doesn't want, an arbitration provision. Even with an arbitration provision, you have to select where will the arbitration take place. Since you don't have a jury, there's less of an issue about where, and the formula that I just provided you with, where the filing party files in the other person's jurisdiction is typically more workable with an arbitration provision in place. Let's talk about indemnification. What is indemnification? I always refer to indemnification as private insurance. And what that simply means is that you agree or ask for protection from the other party or coverage if for some reason a suit arises because of something that you did or I did. I know that sounds like, what are you talking about? All right, so I sell you parts to make a lawnmower. And I don't know, or I just sell you engines. And I don't know exactly what you're going to use the engine for. I think you're going to use it for a lawnmower. And I say to you, all right, I'm going to sell you this engine. But if you end up getting sued for anything that you do that causes a lawsuit because of the way you use the engine or the way you assemble the engine or include it in some other machinery, then I want you to indemnify me from any lawsuit. Meaning if a lawsuit is filed against me, you'll take care of it for me. And the reverse might occur. The seller might be asked, so I sold you the engine and you say to me, you know what, if I get sued, because I'm going to use your engine, I'm going to put it in a machine and I'm going to sell it. But if that engine doesn't work and I get sued because you gave me a faulty engine, I want you to indemnify me for that. And I would say, you know, that makes sense. I've got a warranty in there, fine. Indemnification is simply each party accepting responsibility for their own behavior and fault and contribution towards any adverse outcome that comes in. And there's some very, very detailed language that can occur. I've really oversimplified on some level the indemnification. But that's basically what it means, is that one party agrees to defend the other if a lawsuit arises because the party that's defending the other is the party that was really at fault. Now, a lot of these can be covered by insurance. I want to caution you though, and I'm going to talk about insurance broadly, and then I'm going to narrow in on the indemnification. So a lot of businesses buy insurance to cover risk, and that risk is typically being sued. And that suit can come from customers, but it might also come from third parties that are using in the line of your product. I always use the lawnmower. I sell you the engine, you assemble it into a lawnmower. You then distribute the lawnmower to a store who sells it. I can get insurance typically for lawsuits that occur because the consumer gets hurt using the lawnmower and claims that I provided a faulty engine that led to that problem. But if the consumer sues the seller of the lawnmower, the person who assembled my motor into the lawnmower, they sue them. And that person turns around and asks me for indemnification, and I then provide indemnification, but have not secured indemnification insurance, the carrier might not accept that indemnification claim. And the difference is really simply that I'm not being sued under the terms of coverage. I'm being sued under a private contract between me and my customer. And so I only point that out because if you have serious indemnification risk, you need to have that risk insured specifically by the insurance company. I'll give you another example. We used to represent a carrier of railroad employees, and the railroad would say, okay, look, you're going to be transporting our employees to and from different locations. If you get into an accident, that employee is going to ultimately sue for FELA, which is a federal like workers' compensation, and they may also sue you for the auto accident. If they sue us for any reason, we want you to take that case because you were the driver of the car. So we say fine, right? So we provide an indemnification clause, and then there's an auto accident, or there's some accident that occurs that triggers the indemnification clause. We go to the carrier. We say, hey, we've got this claim. Carrier says, that's nice, but that claim is not covered. That is a third-party claim that is not covered because you don't have that kind of insurance. So with that client, we literally had to provide the contract to the insurance company and ask them to make sure we had coverage for that indemnification provision. And they provided us a rider for that. So just always remember, indemnification is a contract claim, and a contract claim needs to be covered by contract coverage, and most insurance does not provide contract coverage. There are provisions in terms and conditions that might require, like if you're going to indemnify me, I might ask that you actually provide insurance for that coverage, or excuse me, for that indemnification. And I might even ask you to provide me proof of coverage, and vice versa. I've seen situations where the seller of goods has been asked to provide coverage. So I sell the lawnmower, and the buyer of the lawnmower engine says, we would like you to add us as an additional insured in case we get sued as a result of your faulty engine. That can work too. You just obviously have to make sure it's clear with the insurance carrier who the parties are and what coverage is being provided. Last on our list of optional contract terms that could be negotiated in the terms and conditions is the statute of limitations. So contract statute of limitations can be 6 years. Product liability related claims could be 4 years. What you want to do if you're the seller is you want to limit the length of time under which you can be exposed to any claims. So for example, I sell you the engine. I tell you Any claims that you may have against me, whether under warranty or otherwise, have to be brought within a certain time. Let's say a year. I've seen contracts where they say all claims for defects in the product or other problems with the product have to be brought within 90 days. You have to notify us within 90 days. And you got to be really careful if you're the buyer in that situation, because let's say you buy product and you put it in your warehouse and it never gets through the warehouse until the 91st day. On the 91st day, you find out there's a problem with the product. You call me as the seller and you say, hey, this product you sold me has a problem. It doesn't work, just doesn't work. And I say, well, you're beyond the 90 days. You should have notified me within 90 days. So a lot of times there'll be a language put in the contract that says within 90 days after the product has been put into use, or some other language that helps with the warehousing component of what's going on. And the buyer likewise will want to expand the statute of limitations and maybe again, not expand other than to say, in the language, the example I just gave you, they might say the 2-year statute of limitations for, or the 1-year statute that you're providing me for bringing any claims as a result of the sale of these goods, I want that 1 year to start when the product is actually put in place. If the product sits for a long time and isn't put in place later, that could really extend the statute of limitations. And I've had clients with the kind of goods they sell, the integrity of the product is compromised after a certain amount of time and therefore more susceptible to a failure. So these are all obviously operational and industry considerations that need to be understood and evaluated, which, by the way, all these things I've just talked about now, right? All these kind of nuanced details about the type of industry, the type of product, those are items that your AI are not yet prepared to address. They just have not. So when we get to the ChatGPT use for contract and sales, these are things that would be missing or be mishandled by AI in that process. All right, let's move on to then what ends up becoming the battle of the forms. So what do you do when the purchaser sends you, as a seller, you're a seller, and the purchaser sends you a purchase order, and the terms and conditions on the purchase order are different than the terms and conditions in your document? Well, there's a lot of different ways that each party can respond to the other. They can expressly reject, and I've seen this on the acceptance form. It says, we accept the terms and conditions insofar as they are not different from the terms and conditions provided in our documentation. Or we reject all terms and conditions that are inconsistent with the terms and conditions that are in our documentation. This really requires somebody in your organization to look at the documentation in each of the transactions. Now, I've had clients who have tried to do it this way. One, if they have a lot of transactions with one client, they'll try to do a master service agreement with then purchase orders that are part of that master service agreement. And the terms and conditions will all be negotiated in the master service agreement so that they don't have to be handled on each transaction. If it's the concern that I do 1 million transactions with 1 million different customers, I really don't have the ability to look at every single piece of document I get from my customer. Then I've seen the seller of the good to put language in there that says these are the terms and conditions, and any terms and conditions offered by the purchaser that are inconsistent are expressly rejected. Like they put that right in their initial terms and conditions. So what's the outcome of this? Well, the worst case scenario really is not, depends on which side of the fence you sit on, but the worst case scenario is that the law says when there's a conflict, both terms are thrown out and we go back to the UCC. So how does that help us? Well, if you're a buyer, it helps you better than if you're a seller. Because if you're a buyer and your terms are inconsistent with the terms with respect to warranty, and they're both thrown out, and now you go to the UCC is going to provide favorable terms to the buyer versus the seller. There are situations where as a seller, you really have to be vigilant to determine whether your terms and conditions are subject to being eradicated because they could be inconsistent with the terms and conditions of the entity or person buying your goods and services. The other question I get a lot of is, in the terms and conditions, we always have terms of payment, right? And what happens if they don't pay? Well, one of the things that we recommend in the payment is that you have a penalty. Number one, every effort that is implemented to collect payment should be also subject to attorney fees. I'll give you a story. Literally at the same time, I had two different clients who had $5,000 transactions. I mean, within a couple of dollars of each other. One of the clients came to us. They did not use our terms and conditions. They came to us. They sold their services. They had $5,000 owed to them. They had no attorney fee provision in their contract terms. And when we called opposing counsel to try to negotiate and get the payment, basically the response was, it'll cost you more to pursue this than you'll recover. And they were right. So our client had to decide how much money they wanted to spend to try to chase $5,000, and it wasn't very appealing for them to do that. There are certain ways. I mean, they went into small claims court, but it's a problem. There's not any leverage. On the other side, we had a client, $5,000 using our terms and conditions, attorney fee provision, as well as interest on the overdue balance. And we called the other side and said, you owe us $5,000. And if you don't pay, you'll also owe us for attorney fees. And that payment was received within like 60 days. Because instead of saying it'll cost you more to chase us, we were able to say it'll cost you more to not only defend this, but it cost you double to pay us, as well as you paying the debt. What are some other measures, though, that you can go to protect yourself? We have clients that we've designed packets for on initial customers. So a customer comes to us and says, hey, we'd like to buy your product. We'd like to buy it on a regular basis. We send them a new customer questionnaire. You'll see here, and it says the pre-sale credit checks and questionnaire. We'll send them a questionnaire, and those questionnaires will ask them very simple. Are you solvent? Have you had any lawsuits or claims filed against you by customers or vendors? Or we just ask these simple questions. And in some cases, if it's a small customer, we'll ask them to personally guarantee, or we'll provide within the language security agreements, meaning that the product I sell you, the title to that product doesn't pass until we receive payment, so that if we ever have to go get that product, we can do so. And if you ever end up in bankruptcy, we at least have a claim to that product. So these are just, I mean, this gets a little bit more complicated than it looks, but or than it sounds, but it's still very doable. It has worked. I could give you a handful of clients that has saved them time and time again, because they've done the questionnaire with every new customer. The questionnaire provides information that they need when they are not receiving money for their product. And in some cases, the security agreements on that product protects us or protects our client. And in some cases, the personal guarantee allows us to go after them individually in a lawsuit. The other reason that questionnaire is important is because if they misrepresent their status, if they say they're solvent meaning they have more assets than debts, and they're not, or that they've been timely with their creditors and they're not, those are misrepresentations, and those misrepresentations allow you to go after the individuals and certainly allow you to contest any dischargeability in bankruptcy. The last thing I mentioned is the collection procedures. The Fair Debt Collection Practices Act really protects mostly consumers. And again, you have to be careful. Let's go back to our roofer. He does work for, consumers as well as commercial. He has a letter, pay me or else, but the letter he sends to the consumer doesn't comply with the Fair Debt Collection Practice Act. So we had to revise that for him. So it's just, again, when you have consumer transactions, going after them for debt requires you to jump over some hurdles. And if you don't, it could be really a problem for you. All right. These are the types of insurance. I just threw this list out there. And I did that in order to kind of zero in on the kinds of insurance that you might want to consider when you're into these contract terms and conditions. Obviously, these are all kinds of policies or coverages that you can obtain. But you see, I put in there the indemnification clause. A lot of time there might be a business property or business interruption clause that's relevant. So these are just, again, recognizing that when you have contract terms and conditions in the sale of goods or services, it's really smart to have an insurance broker that you work with who understands your business and understands that every aspect of your business has coverage, and they can provide that coverage for you. We have a couple of brokers that we work with very closely. And if you don't have a good broker, here's another example. You are worried about the indemnification clause, so you send it to your agent. Your agent says, I've checked with the carrier and they've said it's covered. I always recommend a letter confirming that. Dear agent, we sent you this. We asked you to make sure we had coverage. You assured us that we have coverage. Thank you very much. Because later when you submit a claim and you don't have coverage because the carrier denies it, and your agent says, well, gee, I didn't understand the nature of that coverage, you now have a claim against the agent for the loss that you would have otherwise sustained because you didn't have coverage. Let's go to AI for a minute. So you've all been hearing about ChatGPT. I assume you all have. It's a really interesting area. I've had clients call me and say, hey, I just asked ChatGPT for a customer contract for a manufacturing business. That's what I asked ChatGPT for, and this is what they gave me. And it's interesting because when I look at it, it's on its bare bones, has the things we talked about. What's the purpose? What's the price? What's the delivery? What's the warranties? Limitation of liability. But then in looking closer, noticed that there's nuanced language that's missing with respect to some of those things we discussed earlier about when does the warranty start to apply? Does it apply immediately? Does it apply for an extended period? Does it apply once the product's put in use? When does it terminate? What are the limitations on the warranty? Is there a limitation for using the product beyond the proposed specifications or the proposed application of the product? Remember, product has all kinds of things that are related to it. Is it designed correctly? Is it manufactured correctly? Is it assembled correctly? Is it being used for the right application? All of those things can result in a problem that may not have been addressed specifically, and therefore may not provide protection or may provide liability if it's not done correctly. I can tell you that we have had a couple of guinea pig customers, clients of ours, work with us to run a ChatGPT request for a document, and we have spotted there are problems in those documents. We did something funny. We asked, we had a meeting the other day. We asked ChatGPT to tell us all about the people at the meeting, and the stuff they provided was like 60% right, maybe 70% right. And in these contracts, they're probably 60 to 70% on point, but it's that 30% that you could end up with a problem. So I'm not saying don't use it. I'm saying use it with caution. And you should certainly, whatever you do, always have your attorney look at this, at this final product. Same thing with, employment manuals. I know this isn't the topic of our conversation, but I see this so frequently. Business owners are very willing to help other business owners. They call each other, hey, do you have a employment manual I could take a look at? They get 3 or 4 employment manuals. They say, oh, I like this. I like that. They cut and paste, and they come up with an employment manual. And then a problem arises. And when you look at the employment manual, one employment manual had terms of art, terms that were capitalized and defined that were cut and paste, but not consistent with the other terms of art or lack of terms of art. And then all of a sudden there's a problem. And even under that scenario, if the client says, hey, would you take a look at this? I put this together, take a look at it. A quick review can tell the customer or the client you have a problem. Okay, last but not least, we do this in connection with our CM6 risk assessment. Today we covered customers. I think last month we covered employees. Maybe next time we'll cover competitors. But the bottom line is, as a business, if you haven't taken the risk assessment, you should. It's free. I think we've got, I thought we had a barcode, but I guess not. This barcode is supposed to pop up here, but for some reason it didn't populate. But that's all right. Go to covermy6.com. You'll see there's a CM6 risk assessment. It's free. It's like 15 questions. It gives you a report card. It tells you out of the 6 areas, these 6 areas up here that we have potential liability, where in those 6 areas you might have risk. So I think that covers it.
Thanks, Lou. I actually
don't know if
just
anybody has
dropped
questions. What's that,
Oh,
Cassie?
yep. I was just mentioning, I dropped the link to the survey in the chat if anybody would like to take the free risk assessment.
Great.
And yeah, if anybody has any questions, please feel free to unmute yourself and jump right in.
Yeah, please ask me. It's better. I do much better with questions than I do with droning on, as long as I do. This is why I don't like the webinars. I like the live audiences, and I can dance in front of a live audience. So anyway. Any questions? All right. I hope, if not, I hope this was really helpful. If anything I said to you today seems a little confusing, please reach out to me. Or if you have a follow-up question about something, or you're unsure about something, or you had like an aha moment, like, wow, I didn't know that. Can I talk to you more about that? Please send me an email, follow up with me. I'd be happy to talk to you.